Good evening and welcome to Realty Coffee Talk on Awaz Entertainment in Canada around the world. My name is Tahir Qureshi. I'm your host. Tonight we will be talking about key players in real estate transaction, and my honorable guest Sean F. Khan, barrister and solicitor, is joining me. Welcome to Realty Coffee Talk.
Thank you so much. Firstly, I'd like to thank you, Mr. Qureshi, for giving us the opportunity to be here today. A little bit about me. My name's Sean Khan, as Mr. Qureshi just introduced me. I have my own real estate law practice. We're based out of near the Square One area, so heart of Mississauga, off 4 Robert Speck Parkway, and the focus is on real estate and business law.
Fantastic. So when we talk about key players in real estate transaction, a couple of things comes into your mind. Am I going to hire a real estate professional to help us do the transaction? Do we need a lender? Do we need to arrange financing? Do we need a home inspector? Do we need an environmental specialist? Do we need an appraiser to get the appraisal done to make sure the financing is done right? And boundary surveyors are needed. Do we have to have a survey, or do we need a surveyor to do a boundary check? So this becomes kept in mind when you are talking about real estate transaction. And of course the lawyer. The lawyer is the one that implements the agreement of purchase and sale when it's negotiated. The topic is at what stage is important for each person to participate in a transaction. When an agreement of purchase is negotiated and given to a lawyer, everything that's supposed to be done and put into an agreement between two parties is already done.
Yeah.
So I'm going to come back to you, Mr. Khan. Is that how do you see that? What is the practice and how do you feel that it can be improved when somebody is entering into agreement of purchase and sale? So let's begin the conversation there.
Absolutely. I think it's a good point to start off tonight with. It's such a common issue that we get to as real estate lawyers. I'm sure if you ask most of them, one of the biggest topics that we say is we're getting the transactions usually when the agreement of purchase and sale is finalized, which means you most of the time get a firm deal. Sometimes you have a little bit of a margin where it's not a firm deal, but you have a condition. Usually it's financing that we see or inspection. But by that time, the deal is pretty much certain. And as Mr. Qureshi brought up too, lawyers are the ones that are taking the deal over the line. So you have a lot of agents, a lot of individuals that help build the transaction, but to take it over the line are the ones when you go give your agreement to your lawyer.
The question I have for you is how often do you see the client or realtor recommends you prior to submitting an offer and consult with you what type of conditions are to be in the agreement of purchase and sale and what are the language that needs to be used? So what is your experience on that?
I would say, I mean, with the agents that I network with and I have in my circle, they have an understanding that if you bring an agreement to Sean, even before the deal is submitted perhaps, or prior to, formalizing the terms and conditions, I will review those. I will make the time to review those agreement of purchase and sales and see, I should backtrack. Before even reviewing it, you need to know what the client wants. What's the client's intentions? A lot of the times, the experienced agents, they do realize, okay, this is a residential property. They want to use it for primary purposes as in moving in and occupy the house themselves or a family member. But sometimes it might be for rental reasons, and other, maybe they want to do construction and flip it the house after later on. So firstly, to start off would be what exactly is their purpose for the house? And then secondly, accordingly, we could tell them, perhaps you need this condition. Maybe we can draft the agreement in a way where we can foresee issues in the future that where the deal was the deal firm, I don't have much power to negotiate. And at the end of the day, it reflects poorly on the client because at the end of the day, it's their home.
Yeah, but this is where very important is that when we are creating a team in the beginning, I have suggested in my various episodes that you form a team before you commence your process of acquiring a property. Yeah. You have to hire a realtor, you have to buy a home inspector, you have to go to the bank, get a lender, you have a lawyer, inspector, appraiser, everything. Why not use the most important person, which is a lawyer, yeah, who is implementing your agreement of purchase and sale? Yeah. In the part of the team, I don't think there is any additional cost that they have to give you in the beginning or at the end, yeah, because all the commitment has already been done in the agreement.
Yeah, so with that being said, I'm just going to backtrack a little bit. When you're purchasing a condo, usually you're putting in an offer. Everyone knows you have a status certificate that you want to review. Most of the time, real estate agents say, okay, I have a lawyer, he can review for you, and it's very time sensitive with the multiple offers that's going on nowadays as well. I would use the same idea with these agreement of purchase and sales. If you can have a lawyer review the status certificate within that time before you submit your offer, do the same with the agreement of purchase and sale. It won't take us that long. Obviously, depending on how busy the attorney is, sometimes you can't make it in the time, and that's why you're upfront with them and say, no, go somewhere else. To answer your question, is there a charge behind it? Absolutely not, because if we're finalizing the transaction, for us to review it, it's going to be easier for us to complete the deal if we're getting the say in it in a way.
And your contribution makes a sense there, because if you are crafting terms and conditions and you see that there are some unusual circumstances where a realtor or the buyer client, for example, if he is buying it, they should speak to a lawyer and discuss possibility, because most of the time real estate professionals do talk to the lenders and inspectors and appraisers and surveyor people. Why not the lawyers? And I always seen it most of the time, the transaction is completely sent to the lawyer and there's nothing they can do about it if there is a mistake or error or oversight in there. So this will be very great and help in case they come to you at that stage, correct?
Absolutely, because at the end of the day, we are able to review the agreement. We can tell exactly what is, as I said, first interview the client, see what their intentions are for the property, and perhaps foresee issues that could arise, because we do this on a daily basis. So we have seen deals where, for example, clients have waived financing conditions. Next thing you know, they're unable to come up with the funds come closing day. Now you're in a predicament. Are you going to be able to close the deal? Do you need an extension? Will you be in breach of contract? So that's just one topic that you could discuss on. There are plenty other areas where we could foresee what may happen or may not happen that could be prevented should we review the agreement.
Yeah, this is actually, you touched a very critical point, because we have our Ontario Real Estate Association had crafted some clauses for this specific purpose, in case if there is a delay from the lenders to give the money, or some registry office, land registry office is not working to close, or some disability, some other circumstances where that transaction is delayed. So it allows a couple of days of time extension to make sure that nobody's abusing the system, but also getting things done right. So this is very critical. So you see those clauses mostly in the agreement now that are coming to you?
Yeah, we are seeing those clauses in the agreements that are coming to us too. But even if, just to talk about the same concept, say you have a condition and you've waived it, now you have a firm deal. It doesn't necessarily mean that you're not going to get your dream house or the seller is going to sue you, whatever the case might be. The reason why that is, and what we've seen in practical scenarios, is everybody wants to close the deal. Whoever the parties are involved, whether it's the seller, whether it's the buyer, the agents, the brokers, the lawyer, everyone wants to make sure the clients are satisfied buying, selling a property, and at the end of the day, to make sure the transaction works, because it is an individual to individual in most cases that are buying and selling the property, and people just want to close the transaction. So if you do see issues because of conditions not being satisfied or a breach of contract, essentially, there are ways around it. It's not always, litigation. No, litigation is the last thing that we recommend to our clients, because there's always ways of settling that. And a lot of times, and it is practice now to see extensions being granted. So if you couldn't come up with your financing, or whatever the other reason might be that you're not able to complete the deal, if it is something time sensitive, usually people are lenient and they do allow the extra few days.
Yeah, because in this the coronavirus situation, everybody is involved with that. Everybody understands now the impact it has caused everybody. So people want to make sure that transaction take place and they are cooperating. And this was on our various episode we talk about working together as a Canadian to helping each other, not to take advantage of the situation, to cooperate and make sure that things are done right. Now, how do you see a differentiation between a freehold, which is a detached home or semi-detached home, or even townhomes, or condominium, we're going to talk about for now for resale. Then we can add a little bit toward about the new construction stuff. So how do you see the differentiation our consumer reviewers can appreciate and understand legal perspectively how it is being done and how they should, there are pitfalls, and also watching things
Absolutely.
to make sure that they understand the process.
Yeah. So we'll start off with the condos. Essentially, when you're purchasing a condo or you're looking at, well, if you're selling it, so you've already been through it once, but most of the time when you're looking at buying a condo, you have the condo corp that are essentially the owners. And what happens is it's something known as a status certificate. Those of you that have bought condos before, you know all about it, those prospective buyers as well. And recently, just over the last week or so, our office has been getting so many status certificate reviews of the same building as well. So there'll be multiple units that are listed just because so many offers are going through. And we don't advise this at all, and I don't think any of the agents that I know do this at all, waive the review period for status certificates
Mr.
because
Khan,
it's essential.
can you add up on the status certificates?
Yeah.
What are you really looking at? Is the viability of
so excellent question there, and there are very topical things to discuss too with the status certificate, and I'll come back to this in
Just
a second.
a few of
but
them
to
to
answer
get-
your question, financials, is the corporation operating in good financial standing? Most importantly, are there any judgments or lawsuits that are being commenced against the condo corp? You may be wondering, watching today, why do I care if they're being sued? Well, at the end of the day, you're an owner into the condo.
And what
corp.
is the impact on
Yeah.
the new buyer?
Right.
But
So
the liability and obligation.
One of the most common impacts on the buyers is at the end of the day, people want to watch out and look out for their financial prospects and best interests. You could see if the status certificate is not reviewed properly, or the condo corp is subject to a judgment that is ultimately given against them, your common element fees could go up. Those could be enforced against. At the end of the day, your financial.
There could be a special amount judgment over and above the monthly
Absolutely.
fee,
And
correct?
at the end of the day, because you are an owner as well, they can come after you for that. But that being said, to answer your other question about what else is, why is it so important to review the status certificate, you have the bylaws of the corporation, so things you can or cannot do. And obviously you have the Ontario laws, you have your city laws, but you also have the condo corp's law. So there's certain things you can or cannot do. A very interesting one that we came across not too long ago, a few days ago, was a smoking regulation.
Yeah, we talked about that.
We discussed this.
Yeah.
Did you discuss it on the?
No,
you didn't discuss it here.
This
So-
is a great time to talk about it.
So basically, the board of directors, they had gotten together and they passed a resolution. They enacted a bylaw essentially, and it was a no smoking bylaw. One would think, watching it, no smoking, it goes without saying you can't smoke indoors in the common element areas because Ontario has such rules to prohibit that as well. But no, this is not what it means. It means confined in your unit, so you own unit 101, for example, you can't smoke in that unit. Whether it's cigarettes or whatever it is, you can't smoke at all. And the reason for that, and Mr. Qureshi and I were discussing it too, casually as well, and we were saying that, well, at the end of the day, your neighbors could be suffocating or being secondhand smoking, for example, as a result of your smoking. I have a different view on it. I'm going to keep my view aside.
Sure,
perhaps.
of course.
And you know what? I'm going to say my view for a second anyways. The reason why I say that, okay, I understand that there are other individuals that, might be impacted by it. But legality, if you think at it the legal perspective, you own a unit yourself. It is your four walls. Now people are telling you what you can or cannot do in the unit. That's just my little input on that. By no means am I criticizing the law. I'm just providing my opinion there.
Yeah. No, the other important question that I always talk about is when you're buying a condominium is about reserve fund studies. That requires about 3% of the total revenue to put aside for contingency, because sometimes city is not happy with the status of the condition of the condominium. And then you have to incur the money, and the reserve funds will help you. It has to be done every 3 years, I believe.
So when you contribute towards your common element fees, so you'll have your monthly fees. This is applicable to condos mostly, and a portion of that is dedicated towards the reserve fund. So on a rainy day or whenever the corporation needs to upgrade, needs to spend money, this is where they go to. So as lawyers, one of the things that we will read and look into is when was the last reserve fund study conducted? What is it implying? Could there be a contribution increase towards this fund in the near future? And as such, our client or our prospect client, in the case that we're just reviewing it before we get the deal itself, What are they looking at? Most people, they don't want to spend more money or at least hidden fees, for example, that they move into a condo. The element fees are, say, for example, $350 or low. I don't know what you can find for that nowadays, but still, the increase on that it goes up to $450 in a few months. That's one of the things that we would do as well. At times when the questions are very specific to financials, because sometimes the corp's financials are audited, unaudited, my firm, we say you need to get an expert accountant to look over that to ensure that you are getting the proper accounting advice that you need as well.
Fantastic. So our viewers, you have understanding of it. The lawyer, when he or she reviews the status certificate, there's about 100, 200 pages of descriptions and statements, and some are audited. It talks about the maintenance fee due for that particular unit that you're buying, and also the see if there is any work orders from the city to improve the building, or contingency funds for reserve study that Mr. Khan has mentioned about that. So these are the purpose is to see, to make sure that the corporation that managing this condominium is viable and is stable, and there is not much legal liability in terms of litigation or any claim. Because if somebody falls on the property and got hurt, and because nobody did a salt in the winter and trip and get hurt, they're going to sue you. So that's the risk you take when you buy a condominium, because it's a joint liability.
Absolutely. To add on to that, because you're discussing insurance as well, with condos, a lot of times you'll realize, and this is very important as well, to review the status certificate, to review the declarations of the condo corp as well, or the rules, because sometimes you'll have multiple insurance policies that they need the purchaser to obtain. So one would be liability. The condo corp would have their own insurance, and we want to make sure they have their certificate of insurance, which is intact, and the coverage is enough. So that's very important, obviously, for them to have. But then as a prospect buyer, you may need to get multiple types of insurances as well. And why I say that is sometimes people forget to budget these things. And at the end of the day, if you don't budget this and then you realize, oh, it's closing day, hey, Sean, we're going to close today. And I tell you, well, listen, the condo corp wants these insurance policies that you need to get, whether it's content insurance or additional liability insurance. And you're going to look to your lawyer and you're going to say, well, I didn't know about this. And that's an extra $100 that you have to pay per month. So that's also something you can find out.
I'm going to take your conversation to a different level. Because when we talk about a condominium, we also have freehold townhomes, which also have a parcel of tied land, is POTL. So maybe you can get the viewers, if you have an understanding of parcel of tied land, mostly condominium, new condominium, city doesn't want to do the road maintenance.
Right.
So under the road, there are sewage line, water line, electricity, and that complex that you create, which has a POTL, you are responsible for maintenance of that. Most cases people say it's a road maintenance, snow removal, but I believe that it is everything within that road is a responsibility of this.
Absolutely.
So do you want to say something about POTL?
Well, to add on to that, I think you've summed it up in a really concise manner, and you've kept it simple. But it's not just, for example, the maintenance. You have your own community. It's your own complex. So the contribution that's being made is to keep that intact and to keep that in a functioning manner, whether it's your snow removal, whether it's a sewage system, or for example, someone is coming in to drill in an electricity pole or whatnot. But I think Mr. Qureshi has summed that up quite frankly in a concise manner, where it's not just the city's responsibility, and which is why you're contributing to this per month fee.
And new construction, that's what doing. I have a client that I bought close to almost $2 million property in Mississauga, and that also had a private gate.
Okay.
And because of having a gate, they have created POTL, removing snow and all that stuff. But I told him that anything under that road is also your responsibility. Maybe it's a brand new complex now. 5-10 years down the line, if there's any problem, city doesn't want to spend their money. And that's why they're allowing this POTL.
Absolutely.
So let's go back to now on the residential freehold homes, okay? Right. So when we have inspection, and sometime the inspection have challenges, there's an issue is that when people are entering into removing the condition, some people think that, oh, send an email to the realtor and don't amend the agreement of purchase and sale,
Yeah.
and leave that some work out of it.
Yeah.
And how they should do it, I always put in the agreement before removing condition.
Yeah.
Because those are conditions that needs to be satisfied.
Absolutely.
And there should be some kind of a monetary value with it in case they fail to do it.
Yeah.
I give you an example of it. One time we have a deal that was supposed to leave a property clean condition. So I put $500 as a charge if you don't clean it. And we held it. They were very angry with me. They left dirty place.
Yeah.
So we were able to use the $500 from the lawyer to get the house clean.
Yeah.
And that's what it cost us.
And I'm sure you put this in the agreement.
In the agreement.
There we go.
So this is very common. Do you see those things coming?
So the broom swept condition, that is a clause that most of the agents always go because you don't
What
want
that mean?
See, that is such a great question. What does that mean? Is that a
Okay,
reasonable
we have a
step?
call coming
Yep.
on the.
Sure.
So Realty Coffee Talk, I'm going to take the call. Hello, this is Realty Coffee Talk live.
Hi there. Yeah, I've got a question about fixtures and chattels. I'm wondering, in the agreement of purchase and sale, if you don't have anything excluded for fixtures, like what? So I've got a specific example. There is a rack that's holding up car tires in the garage, and they're just held there by screws. Is that a fixture, a permanent fixture, like belonging to the house, or because it's just with screws, can the seller take this shelf?
Well, thank you very much for the call. You're on Awaz Entertainment Live, and we are with Sean Khan. Sean, this is a question for you because I always said that a fixture, interior, exterior are included.
Yeah.
So how do you answer this question?
So, sorry, what was the gentleman's name?
What is your name, sir?
It's Bob.
It's a Bob.
Bob, firstly, thanks for your call, and that is a great question. It is an issue that we get quite a lot, chattels and fixtures, and how to differentiate between them. The one key, obviously, most real estate agents that I speak with, I tell them is make sure you differentiate. Sorry, I was looking at the phone thinking it's there. Make sure you differentiate between the fixtures, because anything you don't list that's part of the property, essentially the purchaser could say that this is mine and I'm going to take it with me. So make sure you, when you're listing things as a seller that you don't want to give to the purchaser, it's not included in the purchase price, exclude it. With this rack, one could argue that it's a fixture and it's going to come with the house. Now, depending on how expensive this rack is and how much headache you want to give to the seller, you could make an argument that this is part of the fixture because the agreement of purchase and sale, now I'm speculating, perhaps it says it, maybe it doesn't, but Bob's only brought this question up because I'm thinking it doesn't say it in the agreement. If it's not included in the fixtures, as a chattel, I could argue that this is a fixture. And then the other side would say, no, actually, it's not. It's not fixed to the property or to the land itself, which would, it's very practical and common error between agents or even individuals who own the property to leave certain things out that are meant to be transferred over and take things out that shouldn't be. So to answer your question, it's depending what way you want to take it. If you feel like, the rack's not worth that much, I don't really care, then it would technically be a chattel in my opinion because you can move it around. Sure, it's screwed, you can unscrew it and move it around. But if it's not included in the agreement of purchase and sale under a chattel, one could argue that it is a fixture.
Yeah, I can give you a point. Recently, one of our transactions, the closing, thank you very much, Bob, for calling. And you continue listening our Realty Coffee Talk live on Awaz Entertainment.
Yep.
So now here's the question. Recently we did a transaction, one of our listing that we sold the property. The seller took the mirror from bathrooms. And they said it was special, but we told them that you did not exclude them on MLS on our listing.
Okay.
Therefore, they are part of the normal practice having a mirror in the bathroom.
Absolutely.
How can you remove a bathroom mirror as a personal property? And we have went through the lawyers and they put it back.
Yeah. And exactly, unless you've specified, and this is why it's so important to put these things in the agreement, perhaps you have a mirror that you like because your grandmother gave it to you or whatever the case might be and you don't want to lose it, then you put it in it that this is excluded, we're not going to give it. And some real estate agents are very thorough, they ensure that certain things, or you know what, even I'll add on to that for a little bit. For chattels, for example, you have certain types of stoves, dishwashers, stainless steels, whatever the case might be. And as individuals, you're going in, you're a prospective buyer, you're saying, oh, I love that stainless steel appliances. This is coming with the house. You need to be extremely diligent as a prospective buyer, seller, and the agent, because it's not unheard of where there's a switch tactic that you have a certain microwave or stainless steel appliances, expensive appliances, and they're swapped on closing date, and the purchaser comes in and it's like, this is not the one that I didn't want. That's why you don't just put stove included as a chattel in the agreement. You should put the serial number so you can identify it should you need to. Is this something that you've ever experienced in your practicing day, and have you seen
Yeah,
something?
this is what we do in our agreement of purchase sale that I think you're working two of ours listing. It says that we, as a buyer, have the permission and consent to take picture of appliances. They will be part of our purchase agreement. If you notice that one of the deal that I sent, I think was sent to you by our client, it says that we're going to take a picture. That means picture of the unit, and also serial numbers are in there, picture. So we documented that with the consent of the seller to make sure this is what we're going to get at the closing day. Yes, if you do not specify a stainless steel, GE, or whatever Whirlpool appliances that you are buying, what will happen is that if it's a fridge, it's a fridge. And if it's replaced, that doesn't mean anything, because you need to tie down in the agreement of purchase and sale. This is why it's very, very important to consult with a lawyer when you're drafting your agreement of purchase and sale offer, to have those clauses inside, because mostly clauses are generic.
Yeah, they are. And just to add on to that, we're discussing about chattels here, microwaves, dishwashers, and so on. We worked on a transaction not too long ago, and in the agreement it was mentioned that the dryer is going to be included on an as-is basis. Now, this is something that it was one of the incidents that Mr. Croatian and I were discussing when the agreement is given to a lawyer when everything is firm, so we can't do anything about it. And come closing, my client sold it on an as-is basis, and the dryer wasn't working at all. It was a broken dryer. And then there was a dispute upon closing shortly after that the dryer isn't working. And we had to hold back some funds to provide a credit to the purchaser because of that. But the point of that is it just causes a lot of headaches for the clients involved. And most of the time, if you're buying, you're probably buying your dream house or a property for yourself. And it's a very important investment when you're selling likewise. So it needs to be diligent and efficient in order to make sure you don't miss anything out.
Also, it's very important point is that sometimes you see on MLS, our realtor friends, they tell you the seller has spent $250,000 on the improvement and renovation.
Yeah.
Okay, there are two issues come into the perspective. Yeah. Number one, CRA guidelines are when you're doing extensive renovation, HST comes and plays a role. Yeah. Correct?
Exactly.
And that's why it's very important. Yeah. Number two is to find out that really the seller spent that money. How do we define them in an agreement, and what is your guidance to our fellow realtors and also consumer to pay attention to the details? Because once you disclose that you are spending amount so much money, that you have legality to demonstrate that by evidence that this much money has been spent.
Yeah, absolutely. So there's a number of problems that could come with that, obviously. How to demonstrate that, or how to, if this is disclosed to me as a lawyer working on this transaction, and say my client is the purchaser and the seller is claiming it is a statement. It's at the end, it's advertisement. So they're leading you into believing that they've spent, in this example, $250,000 worth of upgrades. So what I would suggest for, and I'd push for it, whether they agree or they don't, but we have to do our best in our client's interest, is push for a declaration or some sort of an affidavit that would guarantee this, which is a sworn statement that yes, for example, I don't know, I'm going to use Bob. I think he called, that's why. So Bob, to the best of my knowledge, spent $250,000 on this unit for upgrades. That would be one way of getting this. Now, if I tried to do this without there being a reference in the agreement of purchase and sale, The other lawyer's not going to let me get away with that. They will not allow you to do that because you have to look at your agreement. So if this was the case, we'd put a term, and the seller is going to swear that the works did happen. Now, the problem with that also happens with the $250,000 worth of renovations that have happened, something known as construction liens. This is a tricky area. You don't want to get into this. You don't want to be a buyer involving or getting involved in a transaction where there's a construction lien. What is a construction lien? For example, in this scenario, we put in $250,000 worth of renovations. Well, the seller has, obviously, and they didn't pay some of the contractors or subcontractors. Those subcontractors and contractors will go ahead then and put a lien on your property or on that property that they owe them this much amount. Now, as purchasers, lawyers, we want to give you a free and clear title. This is going to cause headaches for us. It's going to cause headaches for the bank or the lender that's financing the transaction if it's a mortgage transaction, and it's going to be a little bit of a headache for the potential purchaser as well. So that's another thing that we do. It's common practice as well, is to get a sworn declaration or some sort of statement that there are no construction liens on the property to the best of their
Before we
knowledge.
take the break, I have another question related to this. When you're doing a lending financing, and sometime the buyer takes a VTB from the seller.
Yeah.
How this impacts the original first priority of the lender when you're taking a VTB, number two, or if you have a second mortgage to make the transaction. How it has to be tailored in the agreement of purchase and sale so it goes through smoothly, because I noticed that I'm also a principal broker of Canada Express Mortgage. I have a license to practice and give my opinion. Is that first priority by the first lender will want the maximum appraised value of the property.
Absolutely.
So there is no money amount or protection left for the second mortgage. And therefore, that's why you end up paying a brokerage fee and also paying a extra lender fees and a high rate. But in terms of protection, what do you see there? We're going to take a break in three minutes. So if you can quickly say something.
I can sum that up for sure.
Yeah.
Well, to answer your question here about the private mortgage or the priority where you're going to have your mortgage. So say a property already has a first mortgage. Now you're going to be you're going to get a second mortgage. So there's two perspectives of looking at it. There's the perspective of the individual that is providing the mortgage on their property. Okay. Then there's a perspective of the person who's providing the money up front for the security. Now, if you're a lender and you're giving yourself a second position mortgage, as Mr. Qureshi said, they want to make sure the appraisal's high enough. They want to make sure they want to be aware of the terms of the first mortgage and see how their security is affected. Security at the end of the day is the property, but you're in second, if not third priority, because the first is going to be most likely the A lender or whoever the first mortgage is given to. So in cases of private mortgages, when you're second, you want to ensure that that house has a legitimate value, and it's not and I'm not saying that this doesn't happen or it does happen, but you want to ensure that if you're the lender, you send your own appraisal, and you get your own appraisal that you're content with, and that you can provide that amount up front to that individual. And obviously the length, how long is the mortgage going to be? And with that being said, for a borrower, you want to ensure that the terms aren't too scary, essentially, for lack of a better word, and that you don't default on it, and next thing you know, you're looking at a lot of penalties and default charges and interest charges, because I have worked on its transactions and even litigation where the other person is in breach, and so we're suing them to recover the funds back, or vice versa. And it's very lengthy and tiring and stressful for individuals involved.
Thank you very much. Viewers, you're watching Realty Coffee Talk on Awaz Entertainment in Canada, around the world. We're going to take a short break. I will come back to you and discuss key players in real estate transactions. Thank you.
एग्लिंटन के इंटरसेक्शन पे तशरीफ लाइए ज़ौक़ रेस्टोरेंट, जायकेदार लजीज खानों का मरकज, पाकिस्तानी, इंडियन और हक्का चाइनीज। आप हमसे लाइव बारबेक्यू, और कैटरिंग के लिए राब्ता कर सकते हैं। राब्ते के लिए हमारा नंबर 9056257786।
जौक रेस्टोरेंट, जौक वालों के लिए।
4 बजे देखिए आपका किचन विद शहबाज गोरी। सुबह 5 बजे देखिए सितारे और हम। 5:30 बजे देखिए मैसेज ऑफ मर्सी। शाम 6 बजे देखिए दीन और दुनिया। इस्लाम इन मॉडर्न टाइम मजर अयूब के साथ देखिए हर मंगल शाम 6 बजे और हर जुमा शाम 5 बजे। थिंक अबाउट इट सलमान कुरैशी के साथ हर मंगल शाम 7 बजे। रियल्टी कॉफी टॉक ताहिर कुरैशी के साथ देखिए हर जुमेरात 7 बजे। टुनाइट टॉक रिजवान असलम के साथ हर जुमे को 7 बजे। देखिए तकरार कीजिए तकरार समीना जबीन के साथ रोज रात 9 बजे। आप देख रहे हैं आवाज एंटरटेनमेंट, आवाज आपकी, चैनल हमारा, जुड़िए हमसे।
Love that chicken from Popeyes. Love that chicken from Popeyes. Welcome to Realty Coffee Talk on Awaz Entertainment in Canada, around the world, globe. Key players in real estate transaction. We were talking our conversation with Sean F. Khan, and we were talking about various aspects of real estate transaction where lawyers play a big role in this transaction. I just want to give viewers and our fellow realtors an update. As you know, we might have received an email from Real Estate Council of Ontario. The Ontario government has new and amended Real Estate Business Broker Act of 2002 to introduce the Personal Real Estate Corporation, PREC. That means now realtors can incorporate a PREC to receive commission from the brokerage. Brokerage has to decide whether they agree or not. That will be an option. So we recommend all our fellow realtors to please talk to your accountant, talk to your lawyer, how they want to tailor the PREC to make sure you understand that. This is very important for you. It's a good development. There could be advantage or disadvantage based on your business. So please make sure that you check with lawyer. Number 2, there was an amendment about advertisement. So advertising term for real estate professional has been amended. So if you are a broker, accept broker record. I am a broker record for City Pro Realty. My designation remains the same. But if you are a broker, you can call yourself a real estate agent. You can call yourself a broker real estate agent. Or you can, if you are a member of Korea, you can call yourself realtor or realtor broker. This is for the broker and broker of record. Then if you are a salesperson, now you are permitted to call real estate agent, realtor. If you are a member of Korea, we are all, majority of our realtor professionals member of Canadian Real Estate Association. Or you can call yourself a realtor salesperson. This is now permitted according to by email. They were sent out to by RICO to all the registrants. So again, I request that you please review and visit rico.on.ca and get more details if you have missed the email from RICO, and also talk to and consult with your lawyer and also your accountant before you work on PREC. Thank you very much for watching. Let's go back to the conversation with Mr. Khan. I'm going to ask you a question. Is that when a buyer comes to you, and what kind of advice you give to them if they come to you, they want to do transaction, and how you deal with the potential buyer who is reaching out to a lawyer? So what advice would you give?
So obviously, first thing would be if a potential purchaser is coming to a law office, it's most likely that they're in the process of buying a house, or they've already submitted an offer and they're waiting for a condition to satisfy or whatnot. In the case that they're a potential buyer where they're waiting to prepare for an offer, obviously the first thing is make sure you have a real estate agent that are the experts that can get you the house that you want. And secondly, ensure the financing condition, or make sure what way they're taking how they're going to pay for the property, whether it's a cash buy or it is going to be through a mortgage. And if so, that would be number one thing I would recommend to them. The legality and the legal work of it, you have to leave that to the lawyers, which is the title searching, which is to ensure that you're getting a free and clear title and to make sure the way that you are going as an owner of the property is in the best interest for you, whether it's a joint tenant or tenant in common. We could discuss that in a little bit later. But just to even add on to that, I would say additionally, you could also have a potential purchaser that is your client, and they'd want to know what is it that we need to do now that we've given you, Sean, the agreement of purchase and sale, and Mr. Qureshi's the agent here, and he's given me the contract. What do we do next? Do you think this is something that we could discuss and talk to them about, maybe step by step?
Again, the idea is to make them aware of that, and if they have interest to learn more about it, they can call you, and we're gonna at the end we're gonna give your numbers to everybody.
Sounds good.
Idea is to make them aware of the contribution the lawyer makes. I believe that all team player, you are working with a team, so you have a brain storming your ideas about buying a property or selling a property. You have this talent available to you and technical capabilities that you can utilize them, expertise. In our law, real estate business broker law, we only talk about real estate. Our law says that we have to seek advice of other professionals. So we don't give legal opinions. We don't give inspection opinion. We don't give a mortgage opinion unless you have a license. I have a license. I am president of a city, Canada Express Mortgage, so I can give you opinion about the mortgage. So that's why it's very important the relevance competency that is required under the law. So you stay within your jurisdiction. So now similarly, when buyer is concerned when he's buying a lot of property, but what role that you play when seller comes to you? Because the seller has to pay commission and other disbursement that comes to you when they sign the listing agreement. Buyer has to deal with the different things. So how do you treat them? What guidance would you give them?
So the generic guideline would be the same whether you're a purchaser or whether you're a seller. But to answer your question about a seller, one of the main things that we want to know firstly is obviously your basic ID checks, verifications. I'm not going to get into that tedious process. I'm going to talk to you more about what we're going to be doing and assisting you. Title. We want to ensure that the purchaser wants to buy your property, they have a free and clear title. And if there are things that are going to be impeding their right to getting a free and clear title, we're disclosing this, and then their counsel is going to advise them accordingly whether or not they can proceed to close this transaction. Everyone knows, or most people in this industry know about title insurance. That is one way of protecting it. And then there's also the lawyer's opinion on the title. In a sale, we're not providing a lawyer's opinion. I'm not selling my title, or we're not getting title insurance either when we're selling a property. But what I need to make sure is when my clients are coming to me, we want to make sure if there's any line of credits, any mortgages, anything, any city liens or any CPL, is anybody suing them? I would like to know this before I do this title search. Everybody works a different way. Why I'm saying that is it saves us time to decide and we can come to a resolution if there are things on title that shouldn't be there, because it's going to prevent you from giving the purchaser a free and clear title on closing. So that is something that we'll look into.
Before we close this subject, I'm going to add something very interesting, because as you know that when you are buying a new construction, most of the time when they go to the builder, they tell them they're buying this property for personal reason. And they know that in a very fine line that the GST, HST is included in the price, but they never spell out that this agreement includes GST, HST rebate. Okay? So what happens is that when the closing happens, they come to the lawyer and they sign a big form that is going to CRA, a declaration that this is my principal property. But that time they tell you, no, this is my investment property. Or it's my personal, but I'm going to sell it. In those situations, how often do you face that? And what is the guidance? Because they're declaring something
Sworn statement.
which is wrong sometime, and it will cost them their reputation and also damage coming from CRA. Because they're going to have, because my understanding is the CRA has now arrangement with the builders to disclose the name of the new buyers. When they were flipping and doing assignments, their name are provided.
So to
So
answer
how-
your question, it's a very topical concern actually, because we see it a lot. This is happening a lot. People are getting into new builds, and there are genuine purchasers that are seriously considering one or the other. For example, number one, you know right away it's going to be a rental property. You're doing it for investment reasons. So when we're doing the cooling period review, essentially you have 10 days when you sign an agreement that you can have this agreement reviewed by a lawyer. And I highly recommend, if any of you have done that, to reach out to us to review these contracts for you. Why? Because we can. There's ways of preventing the builder taking advantage of the purchaser, because there are hidden fees in there. So that's something that will help cap, hopefully, if the builder is agreeable. If not, we'll advise you that perhaps you don't follow through with this. That's a side topic. But to answer the question of this false statement, essentially people make is there are incidents where people change their mind. They want to buy it for primary reasons, but when it's coming to closing, perhaps they can't afford to live in that property. Maybe the mortgage is too high, and they rent it out. Some builders are very, difficult with allowing you consent to then rent it out then. And you have to pay admin fees, their legal fees, and so on, and it's a lot of fee paying. But the other way is where you knowingly know that you're going to be living in the property, and you're still swearing a statement saying that I'm actually not going to, sorry, you're not going to be living in the property, and you're swearing a statement saying that I will be. It's a crime to make a sworn statement, a false sworn statement. That's all I'm going to say in that matter.
Well, thank you, viewers. Thank you very much for watching Realty Coffee Talk. Before we close our program and give my final statement, I'm going to ask Sean Khan to give his phone number and contact information. So you have 1 minute to introduce yourself and give your number, please.
Now, as you guys know, my name's Sean Khan. My practice focuses mainly on real estate, whether it's commercial real estate or residential real estate. We do wills and estate as well, and also business and corporate law. So these are things that every individual, they might need a lawyer every now and then. So we do a free review, as I mentioned earlier. Perhaps I forgot to say the free review of your cooling periods, just to help individuals out. So if that's something you're interested in, you can let us know. We work out of the heart of Mississauga, out of 4 Robert Speck Parkway, and the firm name is SFK Law. So you could check us out on our website. That's sfklaw.ca, and the phone number is 905-232-3735. I had to look at my card to tell you that number because I don't have it memorized. Again, so it's 905-232-3735.
Thank you very much, Sean, joining Realty Coffee Talk on Awaz Entertainment in Canada and around the world. Viewer, we have discussed today key players in a real estate transaction. I hope this episode has given you some inner thought about the process. And if you have any question, you can talk to Mr. Khan, or you have related to real estate, you can call me. If you are a realtor, brokerage, builder, renovator, or home builder, and you want to advertise on Awaz Entertainment, please call 647-484-0018. We have 1.7 million people viewers a month on Awaz Entertainment IPT 580. You can watch on live on Facebook, YouTube channels around the world. So my name is Tahir Qureshi. I'm a fellow of Real Estate Institute of Canada, broker of record for City Pro Realty Inc. brokerage. And you are watching Realty Coffee Talk on Awaz Entertainment. Thank you very much for watching. We'll talk to you soon next Thursday at 7 p.m. Thank you.